With your lordship's mention, Milord had mentioned the matter yesterday also, Milord. Your lordship had directed the matter to come up as to be mentioned today. Milord, however, the matter is not in the list, Milord. Milord, I'll just indicate on the 26th of November, Milord, this is an appeal, Milord, against an order passed by Railways Claims Tribunal. Milord had directed stay of the order, Milord, up till today, Milord, 30th of January, Milord. Milord, the interim order is expiring today, Milord. Will kindly grant extension.
That can be extended on Monday also. Okay, let it appear on Monday.
Milord, I am told, Milord, there's some discrepancy or with the department, Milord. There's some numbering issue, Milord.
The sole appellant, Lordship. Old matter, Lordship, 2017, the matter was filed in the High Court, Lordship.
So let it appear as to be mentioned on Tuesday.
My lord, another thing, item number 46 of today's list, my learned friend here, it may be fixed after 15th or 16th. 46, my lord. 46, my lord.
The 2012 matter.
At 12. That's why I for hearing after 16 or 17 February.
Yes, we are appearing.
The
old man.
My lord.
I've already made it not this week.
My lord, it may be fixed on both sides are here. My
বলো
lord.
তুমি থাকবে না বলো
আচ্ছা এটাকে কাল দিন টু বি মেনশনড দিয়ে দিন সোমবারে এটাকে এটা এই যে
হি ইজ নট
Actually, 3 to 13 I am not available. That's why.
No, I'll fix a date. Let it appear as to be mentioned today.
All right.
It is not this week. Let it appear to be mentioned on Monday.
Monday.
Thereafter, I shall fix a date.
All right.
না এটা নট দিস উইক আছে তো তাহলে টু সোমবারে ওটাকে টু বি মেনশনে দিয়ে ওটা ইয়ে করে দেবো
All right.
আচ্ছা ইয়েস
Lord, I'm mentioning a matter, Lord. The matter, Mr. Singh appears for the appellants. I mean, respondents. Time expired.
The time to deposit check will not expired, my lord.
Okay, to be mentioned Tuesday.
Tuesday to be mentioned.
The records are here. If the records are here, it will be listed on Tuesday.
My lord, disposed of matter. That is the difficulty I was suggesting.
Yes.
It was a disposed of appeal, my lord.
Anyway, but the records must be here to get it listed.
We try to bring the records.
Lord, I mentioned several matters before my vacation.
All the files are lying here, but not a single party is given. So I can put it.
Okay, give it. It will appear in the usual course as to be mentioned first, thereafter.
Judgment, I don't know one.
You are for the respondent.
I am for the appeal.
I am for the response.
মেনশন করা আছে ডিসেম্বর মাসে, নভেম্বর মাসে, সব ফাইল এখানে পড়ে আছে। একটা দুটো কই দিচ্ছেন না তো, দিন না, একটা দুটো দিন না আপনি।
Yes. Hence, this appeal FMA 427 of 2023 fails and the same is dismissed. The judgment and award dated 28/2/2023 passed by learned additional district judge 6th Fast Track Court Alipur in MSC case number 36 of 2018 is affirmed. The respondent number 1 claimant is permitted to withdraw the awarded sum deposited on compliance of all necessary formalities.
I will
Yes.
mention the amount which I deposited.
Matter is dismissed, so he is permitted to withdraw the amount deposited on compliance of the necessary formalities.
Total amount has already been deposited.
Within that.
Whatever is there, you withdraw.
Much.
Ashun.
এটা লিখে নিতে বাবা। চালান নাম্বার, ডেটটা, অ্যামাউন্টটা।
Yes. Call the to be mentioned matters.
ডেটটা ঠিক।
Six. You got item number 6. There are another 2 cases.
Oh, COT.
Death case, 2 death cases. Arising out of একই সঙ্গে হিয়ারিং একই সঙ্গে চলছিল 3টে কেস। হ্যাঁ, এইখানেই আছে দিস কোর্ট আইডার অলরেডি অনার্স কোর্ট। It will be fixed for hearing on after 15, my God. 19 or 20.
Yes, record an order. Learned advocate for the appellant is present. As this appeal is ready for hearing, let this appeal. This is a separate appeal.
These 2 are separate appeal, but they are arising out of same incident.
Okay. So
One-
no cross objection. Separate independent appeal.
Yes, yes.
Let this matter appear along with. This is FMS 672, but what you have mentioned is 192. 192 and 396.
Yes.
That
yes,
means
ma'am.
there are 3 appeals.
3 appeals. Yes, ma'am.
Let this, as this appeal is ready for hearing, let
I
this,
appear on behalf of the appellant in this matter.
let this matter appear along with FMA 192 of 2021 and FMA 396 of 2022 on আচ্ছা 17 তারিখে দেখুন তো কোনো ম্যাটার ফিক্স রয়েছে?
তোরও আছে, my Lord.
17 10:30 কোনো
10:30
আর 16তে 10:30 আছে?
আছে।
Okay, on 17/2/2026 at 10:30 AM.
Instead of 10:30, can it be taken up in the second half? Any Friday second half, my lord, or any Thursday second half, my lord?
Second half, I have to fix for other second appeal matters or original.
Any Thursday second half, or any day second half, my lord, in the after to 3 o'clock or 3 p.m., my lord.
আচ্ছা ইয়েতে 17 তারিখে দেখুন তো 4টের সময় কোনো ম্যাটার আছে কিনা? হ্যাঁ 4টের সময় কিছু। আচ্ছা 7 হ্যাঁ 7 হ্যাঁ যদি আর অন্য আর্জেন্ট ম্যাটার ঢোকানোর দরকার হতে পারে আর কি।
এটা সময় লাগবে, একদিনে হবে না, 3-4টের সময় থাক।
Another on the next day it will be hard out.
মানে we keep it at 4 o'clock on
17/2/2026 at 4 p.m.
I'm grateful.
17/2.
Any We did it. Number 8, I am appellant in all the 3 appeals, my lord.
Yes, 2 will be listed. The other 2 will
As
be
your lordship,
listed.
please, as your lordship.
Number 8, time for the appellant, my lord. If the non-prosecution of an instruction,
Yes, record and order.
This is my instruction, my lord.
You are for the Appellant Union of India.
Lordship,
Learned advocate for the appellant is present.
this is my written instruction.
It is submitted. Hey, what an paper. It is submitted by the learned advocate for the appellant that he has instruction to withdraw this appeal. In the facts and circumstances, this appeal stands dismissed for non-prosecution.
Payment is being made.
Interim order, if any, stands vacated. Let the copy of the instructions filed be kept with the record. Nine also same.
Same.
Okay, 9 also same order.
Grateful, lordship.
item 10,
So in this matter, I am for the appellant, lordship.
এক্সটেনশন করা যায় নাকি?
This is lordship order of remand against which lordship this FMAT was filed. It was admitted on 13th of December. Can one to pending. So interim order granted by this honorable court, lordship.
So when it was admitted?
It was admitted on 13th of December 2024, lordship.
13th of December 2020. Oh, 9/12/2025, another order is passed.
Yes, lordship. Regarding lordship substitution.
Regarding amendment.
Amendment and substitution was allowed, lordship, by your lordship. Thereafter,
Okay, and it is admitted on
December
13/12.
Yes, lordship. 13th December.
So the trial court records are to be called for.
This is an order of remand. If your lordship direct, we can lordship prepare the informal paper book. As your lordship,
Yes,
because lordship,
record.
we have already lordship submitted the special messenger cost lordship for bringing the trial court record.
The learned advocates for the parties are present. Learned advocates for the appellant is requested to prepare and file the paper books within 3 weeks.
3 weeks.
Let this matter appear for under the heading to be mentioned on 23/2/2026. The interim order granted earlier stands extended for a period of 8 weeks or till further orders.
Lordship continue till the disposal. Because lordship, there is no other. Lordship, because
yes,
it is appearing as.
Otherwise, they will not take initiative to.
No,
Oh, is there any execution proceedings pending?
No,
Yes, please.
Oh, simply
simply say remand back and further
okay.
trial.
All further
The
proceeding
interim
was.
order granted earlier is extended till disposal of this appeal.
Grateful, lordship.
My lord, I am appearing on the respondent claimants. Mr. Singh is appearing. My lord, ready for hearing, my lord. Paper book has already been filed earlier.
Yes, record and order. Learned advocates for the parties are present. As the paper books have been filed and the matter is ready for hearing, let this matter appear for hearing on 17/2/2026 at 10:30 a.m.
My lord.
Well, I am appealing for the appellant.
Yes, on
I am for the
the
respondent.
hearing
I
of
have
the matter is concluded and
on-
probably two decisions.
yesterday my lord told me, but I have taken instruction from my senior. My senior told that he does not want to rely upon any judgment.
Acha, record and order. So, as the hearing of this application, what was the can 1 or can 3?
Can one
Can one, my lord?
Can 1 section.
Can one section.
Can 1 of 2024 is already concluded. Let this matter appear for orders on 5/2/2026.
much.
এগুলো ডেকে দিন এগুলো টু বি মেনশন গুলো কমপ্লিট করে দিন আগে না কত এই তো আরো তো আছে দুটো আছে 14 15 16 আছে তো 14 আর 15
I am appearing for the appellant lordship led by Mr. Shobbashachi Mondol.
then you're for the appellant.
Yes,
I appear on behalf of the respondent number 1.
The appeal is ready for hearing.
Lordship, the interim order originally passed on 21st of May 2025, subsequently extended on 18th of December, and the last date of
When it is going to expire.
today is the last date, Lordship,
Okay.
this week.
Was there
Millard.
any direction to file the paper books?
No, Lordship.
Millard, may I just indicate, Millard, the affidavits are complete, Millard, since they are occupying the land, Millard, they are not even paying any occupational charges.
Do we file? Are you contesting that application for stay?
Yes, Millard.
Have you filed that affidavit?
Yes, Millard, the affidavits are
Just
done.
record an order.
Millard, just one thing, Millard. Millard, kindly fixes a date, Millard,
Yes,
because
yes, I'm fixing a date. Let this matter. Order to let this matter appear on
this
16/2/2026 at 4 p.m.
Millard.
Affidavits must be filed in the meantime. Have you filed your opposition and both the reply?
Yes, Millard.
Affidavits must be exchanged in the meantime. Must be exchanged in the meantime. Interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
Millard, the affidavits have been exchanged, Millard.
Already
Exchanged, Millard.
Okay.
Okay.
Okay, if not exchanged, okay. If it is exchanged,
Because my lord, Millard, knows that, Millard, no one can enjoy the land for free, Millard. That is why I insisted.
yes, I've kept it on 16th.
Grateful, Lordship.
Yes,
Great.
let us maintain 1 minute silence.
correction of the collected order, my lord. My lord, kindly see 15th January, order of 15th January.
Down আমি করে নিচ্ছি মামলাটা হয়ে যাও
Order date 15th January.
15 আমি তো দুই দিন
মানে এখানে ডিসপোজাল হয়েছে।
এটা দিয়ে দাও না এটা দিয়ে দাও না
What is the correction to be made?
My lord, kindly see second line.
My lord, paragraph 2, second line, your lordship will kindly have a look. ঠিক আছে
Second line, my lord, kindly see. My lord, 22nd December, it has been typed. My lord, it will be 2nd December. My lord, last paragraph, kindly see last paragraph.
Okay, contents of the order dated 22nd December.
22nd December. It will be 2nd December instead of 22nd December.
Okay, that is the second paragraph, second line.
lordship
হ্যাঁ এই তো 15/1/2026 No, these earlier on 15/1/2026, it was put up for necessary rectification of order dated 22nd December 2025. It should be 2nd December 2025.
Well.
Yes, record an order. Learned advocates for the parties are present. The matter is put up for necessary rectification of order dated 15/1/2026. In order dated 15/1/2026, in paragraph 2, it is mentioned as order dated 22nd December 2025, which should be 2nd December 2025. Let necessary rectification be made. Stop. Other contents of the order dated 15/1/2026 remain unaltered.
obliged, your lordship.
দরকার নেই এটা বাইরে গিয়ে তো
My lord, yesterday I have placed the relevant portion of the judgment that the learned tribunal, my lord.
Yes.
Passed an order, my lord, which is inconsistent with the, my lord, the guidelines of the Honorable Supreme Court, and also, my lord, not considered the matter relating to future prospect and, my lord, the anticipated income of the, my lord, the deceased who died in an accident. If your lordship kindly see the lower court record, therefrom your lordship would found that this is he is an exceptionally brilliant student, and he was, my lord, he has a bright career because he hailed from a businessman family, and my lord, the judge didn't consider the income as proved, my lord, by producing the balance sheet and the income tax return, as well as the payment towards the, my lord, the income for the respective year, my lord. wherefrom it would appear that rupees 46,000 something was the annual income, and 5,000 something was paid towards the Milord tax by the father. And Milord, as such, there was no consideration, neither of the Milord income of the deceased, not Milord. There was no consideration, though in the order itself it was mentioned, the escalation and everything, but no reason was given why the judge had not accepted the Milord, the basis of escalation and all these things. And Milord, moreover, your lordship would found the father who was examined as PW1, he has categorically stated, Milord, even there is corroboration from PW2 that he being a student of class 9, and your lordship knows nowadays even student of class 5 and 6, they are being very much competent in the computer system. And Milord, he is a Milord boy of 13, but he is Milord about 5'7" Milord his physique, and Milord his obituary, given by the issued by the college school authority, that may kindly be seen from the lower court record, and his photograph also may be seen, so that your lordship can calculate that Milord, there is every possibility of Milord to assess the quantum of his future prospect, and Milord, the income from the said comments of his teachers, and also from the witnesses who saw him, Milord, in participating in the business of his father at the while he was reading in class 9. And in Marwari family, Milord, this was actually happened. That was second consideration, Milord, for considering his, Milord, about the future prospect, and also, Milord, the income of the victim. So, Milord, the learned tribunal, Milord, has failed to arrive at a, Milord, correct finding, and without, Milord, considering the other heads of compensation, Milord, awarded 1,54,000 lump sum, Milord, and did not rely and declined to rely upon the documents as produced by the father, the income tax document, which was, Milord, proved by the, Milord, the person who came from the income tax department. He is PW, lordship may remember his statement. And, Milord, that is all the in this case, Milord, because all other issues were decided in the favor of the petitioner. There was coverage of insurance, there was fatal accident, it was rash and negligent driving, everything was there. But 7 except, Milord, the error in deciding the, Milord, the quantum of, Milord, the compensation, which your lordship is to consider in the light of the, Milord, pronunciatory judgment and other judgments, Milord, which has given a sea change, Milord, that even the students, youngsters, they are also entitled to be counted on this, Milord, aspect. And, Milord, so far the guidelines, Milord, in this regard about this computation of compensation, Milord, I am placing to the other one, Joseph. In the second page, Milord, in the last paragraph, Milord, just before last paragraph, High Court has gone by the probabilities and the realities of life. Even if it is accepted that there was no material to show the income from the agriculture or dairy, a rational view can be taken.
Which para? Para 7.
My lord, para 7. কোনটা দিলাম দেখো। Page 2, my lord.
So para 7 you are relying.
Is the state of Haryana, my lord?
It is state of Haryana versus
My lord, this
West
one,
Bengal.
this one, my lord. This one, my lord. That is another, I will, my lord, make my submission on that. In page 2, my lord, paragraph 2, last 4 lines. High Court has gone by the probabilities and the realities of life, even if it is accepted that there was no material to show the income from the agriculture or dairy. A rational view can be taken about the possible income from the agricultural land, which the tribunal did not, and the High
Page
Court.
2 you are reading.
My lord, page 2. Page 2,
Last paragraph.
second paragraph
Yes,
and
yes,
last
yes,
paragraph.
second
Second paragraph at the bottom, and my lord, last paragraph. It has to be kept in view that the tribunal constituted under the Act as provided in Section 168 is required to make an award determining the amount of compensation which is to be, in the real sense, damages, which in turn appears to be just and reasonable. It has to be borne in mind that compensation for loss of limbs or life can hardly be weighed in golden scales. But at the same time, it has to be borne in mind that the compensation is not expected to be windfall for the victim. Statutory provisions clearly indicate the compensation must be just and it cannot be a bonanza, not a source of profit, but the same should not be a pittance. Here, my lord, what happened is a pittance. The courts and tribunals have a duty to weigh the various factors and quantify the amount of compensation which should be just. What would be just compensation is a vexed question. There can be no golden rule applicable to all cases for measuring the value of human life or a limb. Measure of damages cannot be arrived at by precise mathematical calculations. It would be depend upon the particular facts and circumstances and attending peculiar or special features, if any. Every method or mode adopted for assessing compensation has to be considered in the background of just compensation, which is the pivotal consideration. Though by use of the expression which appears it to be just, a wide discretion is vested on the tribunal. The determination has to be rational, to be done by a judicious approach, and not the outcome of whims, wild guesses, and arbitrariness. The expression just denotes equitability, fairness, and reasonableness, and non-arbitrary. If it is not so, it cannot be just. So, my lord, on the, my lord, relying upon this judgment, if your lordship kindly consider the judgment passed by the tribunal in this case, my lord, nothing was considered by the learned tribunal in determining, my lord, the future prospect and the other heads, my lord. Rather, it was arbitrary. The next. My lord, the previous judgment which I referred to your lordship, paragraph 7. Paragraph 7, my lord. It has to be kept in view that tribunal constituted under the Act as provided Section 160 is required to make an award determining the amount compensation which is to be in real sense damages, which in turn appears to be just and reasonable. My lord, I think, my lord, it is a repetition, my lord, because that has been quoted in the second judgment. To be done by a judicious approach, not the outcome of whims. That is Helen Revelo. Okay. My lord, I am reading a paragraph. Thereafter, I am handing over this, my lord, and my junior is also searching the copy, my lord. My lord, in page 14 of the judgment of Mrs. Helen C. Revelo and others, my lord, in second paragraph, so far as the general principles of estimating damages under the common law is concerned, it is settled that the pecuniary loss can be ascertained only by balancing on one hand the loss to be claimant of the future pecuniary benefits and would have accrued to him, but for the death with the pecuniary advantage which from whatever source comes to him by reason of the death. In other words, it is the balancing of loss and gain of the claimant occasioned by the death, but this has to be change its color to the extent a statutory intends to do. Thus, this has to be interpreted in the light of the provisions of the Motor Vehicles Act 1939. It is very clear to which there could be no doubt that this act delivers compensation to the claimant only on account of accidental injury or death, not on account of any other death. Thus, the pecuniary advantage accruing under this act has to be deciphered correlating with the accidental death. The compensation payable under the Motor Vehicles Act is on account of pecuniary loss to the claimant by accidental injury or death and not other forms of death. If there is natural death or death by suicide, serious illness, including even death by accident, even train or flight not involving motor vehicle would not covered under the Motor Vehicles Act. Thus, the application of general principles under the common law of loss and gain for the computation of compensation under this act must correlate to this type of injury or death, namely accidental. If the words pecuniary advantage from whatever source are to be interpreted to mean any form of death under the act, it would dilute all possible benefits conferred on the claimant and would be contrary to the spirit of the law. If the pecuniary advantage resulting from death means pecuniary advantage coming under all forms of death, then it would include all the assets, movable, immovable, shares, bank accounts, cause, and every amount receivable under any contract. In other words, all heritable assets, including what is willed by the deceased, etc. This should obliterate both all possible conferment of economic security to the claimant by the deceased and the intentions of the legislature. By such an interpretation, the tortfeasor, in spite of wrongful act or negligence which contributes to the death, would have in many cases no liability or meager liability. In our considered opinion, the general principle of loss and gain taken color of the statute, but the gain has to be interpreted which is a result of the accidental death and the loss on account of the accident death. Thus, under the present act, whatever pecuniary advantage is received by the claimant from whatever source would only mean which comes to the claimant on account of the accidental death and not other form of death. The constitution of the Motor Accident Claims Tribunal itself under section 110, as the section states, for the purpose of adjudicating upon claims for compensation in respect of accidents involving death or bodily injury. Thus, it would not include that which claimant receives an account from other form of deaths which he would have received even apart from accidental death. Thus, such pecuniary advantage would have no correlation to the accidental death for which compensation is computed, because the finding of the judge is there, tribunal is there regarding the pecuniary damages, because the boy has gone and the money has gone, so it has gone to the father parents, so my lord, he is not entitled to any pecuniary damages. But the court has, after discussion, my lord, court has made it clear that such pecuniary advantage would have no correlation to the accidental death for which compensation is computed. any amount received or receivable not only on account of the accidental death, but that would have come to the claimant even otherwise, could not be construed to be the pecuniary advantage liable for deduction. However, where the employer insures his employee as against injury or death arising out of an accident, any amount received out of such insurance on the happening of such incidents may be an amount liable for deduction. However, our legislature has taken note of such contingency through the provisions of Section 95. Under it, the liability of the insurer is excluded in respect of injury or death arising out of in the course of employment of an employee. Well, this principle also reiterated by the current judgments also, that even the money against insurance policy also cannot be taken into account. Well, I am handing over this judgment to your lordship. So, my lord, I conclude with this because I will give my reply after my learned friend submits, my lord, that I had the learned tribunal, my lord, considered the income as per Income Tax Act, my lord, which also, my lord, has been considered by the apex court in other judgments, that if it generates that there is evidence, because it is not a case of no evidence. If there is evidence that he has in annual income, so that should be the, my lord, the basis of consideration of his computation of his income, my lord. So, my lord, under such circumstances, I pray before your lordship, I leave it to your lordship to consider the case and to, my lord, pass an order and to allow the appeal, my lord.
Yes.
My lord, first I start with the handicap what I face. The paper book, my lord, has got, my lord.
Yes.
My lord, some references were made with regard to annexures and, my lord, the exhibits. My lord, whether my lord's paper book has got any of the annexures or exhibits, my lord, because it is not given to me.
My lord, I had given to him, my lord, my learned friend asked me that he has not, my lord.
Supplementary paper book?
No, my lord.
Only
single paper book was.
Sir, my lord has got it.
Trial court exhibits are annexed here, enclosed here.
No, my lord.
Trial court's documents.
Because references were made, my lord. আমার কাছে তো নেই, আপনার আমার কাছে তো পেপার বুকটা আছে।
না না, আমি আপনাকে তো ইনকাম ট্যাক্স চাইলেন, আপনি আদার কোর্টে।
No, the question, not question of income tax, whether the exhibits of the trial court are there in this paper book.
My lord, in the lower court record it is there, my lord.
So can you argue without those, or do you want those? Then
my lord, I'll proceed. My lord, I'll proceed. My lord, I'll proceed.
Very well.
My lord, so far the, my lord, my learned friend, it appears before the other coordinate bench. My learned friend.
Usually, the trial court claim petition, written objection, evidence.
My lord, it is there. It is there.
It is there in the paper book.
But not the exhibits, my lord.
These are also the part of the document.
I couldn't recollect because it is of 2009, my lord. That's why, my lord. And my learned friend, he says that I need the income tax document to talk to the insurance company. My lord.
Anyway, you see, the learned trial judge has observed with regard to income tax return.
My lord.
Anyway.
And I have given copy.
Very well. Now, whatever his observation is there, you see, that has to be considered. Yes.
My lord, what is the crux of the matter? Your lordship has been, my lord, right from the very beginning is asking, my lord. This is a short case. This is a small case. It wouldn't take long. Not only oratory skill, my lord, would not make a matter big. The crux is one 13-year-old minor, he died in an accident. What should be the compensation? My lord, the latest of the Supreme Court judgments, my lord, have made it very clear that whatever the assessment is to be made, my lord, first of all, it has to be divided into two parts, pecuniary and non-pecuniary. Non-pecuniary has become untouchable in view of Pranay Sethi, 15, 15, 40. Whatever one is entitled to 15 is state, 15 funeral, 40 consortium, if consortium comes into the picture. The non-pecuniary.
They are both the parents of the claimants.
They are both the parents of the claimants. Well, non-pecuniary has become untouchable. Now let's come back to the pecuniary side. I will not argue on non-pecuniary part, my lord. Pecuniary, my lord, again, my lord, what the insurance is all about. My lord is well aware and I wouldn't be troubling your lordship much on this, Milord.
Yes.
To indemnify the heirs of the victim. But this is what the insurance is all about. That's why we all are here before your lordship. And Lord, what is this indemnification? Indemnification, my lord, while assessing in terms of money, my lord, is that on the date of accident, the victim who had gone, who had left, my lord, whatever he was providing to the family, that is the monetary loss on that very day. You assessed particularly that particular loss on that very day. What was his income? And on that basis, my lord, taking other factors into account, his age, the dependents, my lord, are to be taken into consideration, and the assessment is to be made. It is as simple as that. My lord, after, my lord, taking, my lord, the pound of flesh, now, my lord, what is the claimants are coming before your lordship, my lord, is to, my lord, take out, my lord, every ounce of blood. Compensation of 1,54,500 has been granted for a minor. Accident of 2003. 2009 award passed. In 2009, for any case of minor, it was never exceeding this 1,54,500. They have taken that money. And in 2026, my lord, by way of oratory skills and taking advantage of tenacity, give me this, give me that. My lord, all these things are being added before your lordship. Now, my lord, coming as far as, my lord, the claimants are concerned. Claimants are the parents. Both parents died.
Both the
Both
parents
parents died. Yes. Both parents
Both are
died.
claimants.
Both are claimants. Both parents died. Today, two elder sisters, those who are married, those who are staying at their matrimonial homes, they are before your lordship, asking for the money for the death of their younger brother who died in 2003, and for whom the compensation was already granted and received in 2009.
2010 or 2009.
20th August 2009. You know, these two married elder sisters are today here before your lordship. Substitution was made just the other day. Mother died
when?
2015 one death, 2023 second death. Both parents died. So this is, my lord, the sum and substance of the matter. Now coming, my lord, with regard to the income part. Admittedly, a 13-year-old child cannot have any income. He did not have any income. Admitted fact is that he got some gift.
Yes.
He got some gift, my lord, from his grandfathers, or my lord, uncle or aunt, or my lord, the family members. Those gift, my lord,
yes.
What the father did, my lord, he opened up an income tax file for his son. He managed that file. And he showed that those gifts as investment, my lord. It is there in the record. I'll show it to your lordship. And then he paid up, my lord, tax of 5,000 odd. My lord, though, my lord, I don't have exhibits right here, but my lord, I take whatever it is said, my lord, because that is there in the records, my lord. It has been mentioned. Now, my lord, for assessment, my lord, this pecuniary loss, what the family suffered because of the death of the boy, my lord, this assessment we are here to make, my lord. My lord, I counted at least 5 times, my lord, it was mentioned that he was 5'7", 5'7". Yesterday also and twice today. My lord, anybody, those who are here in this court who are less than 5'7", my lord, are we less efficient of it? 5'7" means what? Had he been 6'11", then my lord, it would have been 10 crores. What is this 5'7", 5'7"? The school he was in, my lord, it's in North Calcutta.
What is the name of that school?
My lord does not remember. I'm grateful to your lordship. It was spoken thrice.
No,
Daulatram, my lord, Daulatram Nopani Vidyalaya. Is my lord aware?
The Hindi medium.
My lord, I'm extremely grateful to your lordship.
The medium
My lord,
CBSE.
I'll tell your lordship. My lord in Calcutta does not know about the name of the school.
No, I know the name, but so far the matter of the case is concerned, I forgot.
Lordship,
My lord,
he was
it is
not.
the Hindi medium school.
My
Lordship,
CBSE.
lordship. It was ICSE, my lord, earlier. I do
Now
not
it is
know. present.
CBSE.
No, maybe, my lord. My lord, it is somewhere near Ganesh Taki. So, my lord, it's not Xavier's, it's not Lamarck's, it's not St. James.
There are brilliant students from those.
Of
schools.
course, there are. But the emphasis which has been made before your lordship, not I am on that. 5'7".
Anyway, regarding
Now, my lord, income
regarding
cut.
his mark sheets were shown before the court, were placed. The court has
My lord, the
considered.
exhibits are not here with me. My lord,
Anyway, the
class,
court observed.
my lord, now, my lord, this mark sheet of class 9, what difference would it make? My lord is here to assess the income. My lord, every single case, when my lord, for both sides fight before your lordship, my lord, to prove our case, my lord, what do we prove? The only thing what we prove, my lord, what was it? What was the income of the victim on the date of accident? My lord, do we ever consider the income of the victim 10 years after the accident or 20 years after the accident? Is my lord remembers any single case? My lord, we fight tooth and nail for this year income tax, not last year income tax, not next year income tax, last income tax filed before the death of the deceased. Do we fight here, my lord, before your lordship, every single case? To show what? To show this, that on the date of accident, what was the income? My lord, we file for every single pay slip. I have fought. My lord has considered, my lord, the single pay slip, that yes, on the date of accident, what was the income? Here, my lord, on the date of accident, what was the income? And the proposal is being made before your lordship that my lord will consider a notional income which would be 15 years after the date of accident, or maybe 10 years after the date of accident.
46,650 was the monthly income, probably, or the yearly income.
My lord, I'll deal.
46,650.
My lord, I'll deal with that.
No,
also.
no.
Yes. The income tax return has been there.
46,650 yearly.
Yearly. After deduction of, my lord, 5,000 income tax, it becomes 40,000, approximately 40,000 per annum. That is the best case.
No, this is
Yes.
the yearly income
of the child.
Okay.
As per the income tax, the gifts, admittedly, and after deduction of income tax of 5,000 odd, it becomes, my lord, 40,000 per annum.
40,000 per annum.
That is the best case. My lord, 40,000 per annum. This is what, my lord, a lot of stress has been made. Income. If 40,000 per annum is the income, my lord, roughly, my lord, it comes to, my lord, 3,500 rupees per month. But whether, my lord, in 2003, on the basis of the evidence given, can it be treated as income or not, my lord? I'll straightway invite your lordship, my lord, what learned tribunal judge has taken note of, my lord, and how. Your lordship will kindly come to, my lord, page number 98 of this paper book. Lord, I'm straightway taking your lordship, my lord, how this 46,000 or 40,000 has been dealt with. Page 98. My lord, this award of tribunal starts at 98. Is my lord there, my lord? Grateful to your lordship. My lord, second paragraph. In this case, may I read, my lord?
Yes.
In this case, it appears to me, it is a specific case of the claimants that the victim had income of rupees 46,850 per annum, though admittedly he was a student and he had no personal earning. PW1, my lord, that is the father who is dead, long dead, my lord. PW1 in his evidence stated that the deceased Chirag was gifted with certain amounts by the grandfather. Your lordship will kindly take note.
Yes.
The deceased was gifted with certain amounts by the grandfather and his elder sister, the one who is claiming today before your lordship, asking the refund of that gift. Elder sister, which he invested in various schemes and property, and from the said investments, he lastly earned rupees 46,850 per annum and paid income tax for the last time amounting to rupees 5,390. The claimants also filed copy of the income tax return to prove such earning and income tax payment by the said deceased to prove the actual income of their son Chirag. But it appears to me in cross-examination of the father, P1, where he has stated that the asset which was kept in the name of his son is still under his control. There is no loss. And he used to pay income tax He used to pay income tax on behalf of his minor son, along with his income tax amounting to rupees 1070. Milord, father was so rich. Marwadi. Milord, 10 times I heard Marwadi. He was so rich that his income tax was 10,000 rupees. The father income tax amounting to rupees 10,720, and the son's income was 5,000 rupees. Milord, son's tax was 5,000 rupees, and they were so rich. So much of expectation. Milord, this claim is of more than 2 crores.
Now, how much did they claim in the claim application?
Milord, more than 2 crores.
Oh, on what basis?
Milord, one has gone out of the senses, Milord. Milord, it should be dismissed with exemplary costs. Well, where are we? What are we doing here? Is it a lottery? A death in the family, Milord, is it a lottery to make money? Every single individual, Milord, would pray that let there be the death by a motor accident. And that is why these fraudulent cases are coming up, if your lordship. Milord, in his favor went 539,000 in the name of his son. It is therefore quite clear from the evidence adduced by PW1 himself that in spite of death of his son, the earning through the savings of his son remained intact and under the control of the claimants themselves. In that circumstances, the claimants have no right to take any plea regarding pecuniary loss and loss of earning due to death of their son. The examination in chief on recall of PW1, though stated that the son used to participate in his business and the capital of his business was exhausted because of poor management of their business after the accidental death of their son. But I find that the claimants failed to produce any scrap of paper in support of their such contention. It is not at all believable that a boy of 13 years, who was student class 9, used to participate in the business of his father, and also that the capital of the business of his father was exhausted because of poor management due to his death. Milord, if he was doing business, when was he studying? Milord, these are, your lordship, Milord, is a case of death, Milord, should be taken note of sympathetically. I agree. But Milord, the way the claimants have approached the court, and today, Milord, the pleadings are being made before the court, as if, Milord, I'm shocked and surprised. I'm sorry to say that, Milord. Milord, in 2009, Milord, when at that point of time, Milord, the division bench used to take up these, Milord, MSCT appeals, Milord. After, Milord, 2020, Milord, these MSCT appeals are being taken up by Honorable Single Bench. Milord, 2009, Milord, Honorable Justice Bhaskar Bhattacharya, Milord, as his lordship then was, Milord, he was taking up these MSCT division bench appeal matters, Milord. In none of the cases it exceeded 1,54,500. None. Milord, I can cite, Milord, at least 50 of those judgments before lordship.
Death of children.
Death of children, minor, death of a minor. Justice Indira Banerjee, Justice Somresh Banerjee, Justice Bhaskar Bhattacharya. All the division benches I am referring to, Milord. Death of a minor, 1,54,500. Milord, why I tell your lordship? Milord, for the first time, Milord, this increase in income part, Milord, earlier it was 15,000 rupees per annum because minor had no income. Even for the persons, Milord, who were not minors, whose incomes could not be established, Milord, Supreme Court said that take it 15,000 per annum. For the first time, Milord, in 2008, in Lakshmi Devi versus Muhammad Tabbar, your lordship will kindly remember, Supreme Court Justice Honorable Satyavrat Sinha was there, Milord. He said that a 20-year-old man or 30-year-old man or a 40-year-old man, maybe he could not prove his income. So you take 100 rupees a day. So then, Milord, in 2009, for the first time, this concept of 3,000 came up, 3,000 rupees per month. Prior to that, up to 2008, except 1 or 2 cases, in all cases, it was 15. Forget about minors. Minors, so it was mandatorily 15,000. Even the schedule, second schedule 163 showed that. Even for all major persons, Milord, it was 15,000 per annum. This is the case of 2003. Milord, I wouldn't be troubling your lordship much, Milord, because that is the crux of the matter. A minor, no income, 15,000 was the notional income, was the, Milord, at that point of time. Milord, your lordship is well aware of schedule. Milord, even today, Milord, I'll go a step further. Milord, we are in 2026. Milord, a new amendment has been made in 2019. My lord is aware of that, Milord, which has come into effect in 2022. Milord, in one of the better cases, I'll argue that also, Milord. Just for the reference, Milord, I'll say, in 2019, Milord, the Parliament thought it fit that in cases under Section 164, a total sum of 5 lakh is to be granted. Milord, this 5 lakh is irrespective of the age or the income of the deceased. hit and run cases, my lord, you do not have to prove rash and negligent. But the sum would never exceed 5 lakhs. This 5 lakh, my lord, when I take into consideration, which up to 2026 Supreme Court is upholding, even today, my lord, it makes a rough figure of 3,500 rupees per month. In 2026, Supreme Court is upholding in all these 164 cases that monthly income is not exceeding 3,600 or 3,700. It is not touching 4,000. If that is what the Supreme Court is thinking, my lord, even today, the Minimum Wages Act is not being considered in 164. Everybody is aware. Parliament is aware. Parliamentary debate had been there in 164, my lord, but that also refers to income. But the Parliament did not say that take minimum wages of the deceased.
That is a straight
jacket.
Straight way.
Yet
You don't have to prove the ration.
Extremely grateful. But what is the quantum? Quantum taking monthly income of what?
No, that limit is given.
Limit is given.
Court cannot go beyond that.
So, my lord, when that.
No, I think 5 lakh is the statutory amount.
5 lakh is the statutory amount for all death cases?
Yes. Where negligence is not required to be proved.
Negligence is not required to be proved. But, my lord, I am coming on the part of we are discussing here quantum. Even in 2026, when negligence is not being proved, my lord, quantum is not exceeding 5 lakhs. And when we break this 5 lakh, my lord, the monthly income does not exceed 4,000. In those cases, Supreme Court is not coming, or nobody has challenged that take minimum wages into account, or for that matter, any other amount, my lord.
Question is,
Lordship.
even in the case of a minor, cases like this, you see,
Lordship.
The compensation cannot be more than 5 lakh. Suppose if you take this case.
Yes. Compensation cannot be at best. And my lord, for that, without taking this new act or new amendment into consideration, my lord, Honorable Supreme Court has been giving, my lord, 5 lakhs to these cases of minors. My lord, I would have stressed upon 1,54,500, but lately, my lord, in 2019, 20, 21, 22,
that means in these type of cases, the maximum limit
the maximum, my lord, can be 5 lakhs. My lord, I'll give my lord, the judgment against me, which is not 1,54,500, which is of 5 lakh, which is, my lord, of the view of your lordship, what has fallen from your lordship, my lord, 5 lakhs. My lord, those judgments are here. I'll place one or two those. This at best can be exceeded up to 5 lakhs. At best, otherwise, my lord, it doesn't require any interference. My lord, on the day before, I was in court. Your lordship kindly remembers that registered medical practitioner?
Yes.
My lord, perhaps my lord also remembers the year of accident.
Yes.
Perhaps. Your lordship will kindly match with this year of accident. When a registered medical practitioner, my lord, is deciding, my lord, would get 1,60,000 or 70,000. My lord, what prompts, my lord, in this particular case, my lord, to interfere with this award? I ask this question to us.
Now the question is, considering the latest amendments and the Supreme Court decisions.
My lord, what had fallen from your lordship, my lord said that no, even that registered medical practitioner can treat patient. A person 35 or 40, whatever his age was, I don't recollect. If he can treat patient and his total compensation for his death in the year 2003 or 4 is 1,70,000. But how come for a 13-year-old minor child, your lordship will exceed that amount? Kindly, your lordship will kindly consider that.
Probably, I think that was, yes.
The year was same. Maybe one or 2 year plus minus. 2003 or 2004 it was. If I can recollect here, Miss Mukherjee was one side and Mrs. Mukherjee, other side. Your lordship recollects it was only the day before. So, your lordship said that no, monthly income, would be around.
No, 15,000. No, 15,000 was the yearly income.
Your lordship exceeded that to 18,000 or 19,000, something like that.
To some extent.
To some extent. That is why, I am saying, Lord, how do I bring both these at par? A registered medical practitioner who is treating patient, my lord was also of the view that yes, his death.
Now let us consider that judgment with regard to 5 lakhs.
My lord, the judgments which were cited by my learned friend, my lord, most of them, the reference were not given to me. It was simply handed over to your lordship. But, my lord, whatever I could recollect from his submission, my lord, none of them dealt with the death of a minor. What I could recollect. It was all on the principle.
One was with regard to injury of a minor.
My lord, none was with the death of a minor. None is applicable here. My lord, now, my lord, this Meena Devi, one of the last judgments, my lord, of Supreme Court on this issue, my lord, this case, may I just hand it over to your lordship, my lord? This case gives 5 lakh. Death of a minor, my lord. Including future prospect, every
Consolidated amount.
my lord, it has taken note of, my lord, that is 30,000 rupees per annum, given future prospect, taken note of everything and said, okay, consolidated 5 lakh.
So it has taken 30,000 per annum.
30,000 per annum, inclusive of future prospect, and then other things are there, my lord.
Future prospect, that means how much it comes.
My lord, this 30,000 is inclusive of future prospect. My lord, now in these judgments, my lord, there are so many anomalies. I'll tell your lordship, my lord. This Meena Devi, my lord,
30,000 means future prospect is 12,000. Probably.
No. 30,000 is inclusive of future prospect. Therefore, my lord, it would be around, my lord, 2,000 rupees per month. Then 24.
Is there any scope? There is a 50% on personal expenses.
Yes, it has to be. In all cases of bachelor, my lord, 50% has to be deducted. My lord, I've got 5 judgments here with me. My lord, they all say approximately 5 lakhs can be granted. Whatever the mode of computation is, my lord, by taking note of this Meena Devi, my lord, our honorable single bench, Honorable Justice Ananya Bandyopadhyay, my lord, I'll just indicate to your lordship. My lord, here also 5 lakh was granted. Lord, Meena Devi, paragraph 16, your lordship, is the relevant paragraph, paragraph 16. The minuscule calculations 16. 1/6, Meena Devi.
Yes.
Thus, applying the ratio of the said judgments, my lord, this judgment, my lord, this Kishan Gopal, Kurwan Ansari, those are referred in paragraph 15. I've got those. My lord, in paragraph, my lord, I'll just my lord, pausing here for a moment. My lord, paragraph 15, my lord, refers to Kishan Gopal. Supreme Court, death of a minor.
Yes.
My lord, this Kishan Gopal, my lord, gives 5 lakh. Lord, the judgment is here. My lord, I will not trouble your lordship. Or if lordship wants, my lord, because paragraph 15, reference of Kishan Gopal, 5 lakhs. Your lordship will kindly keep a note. My lord, the mode of computation may differ, but the sum total, my lord, I'm trying to assist your lordship, is 5 lakh. Kishan Gopal, your lordship will kindly write down at the top 5 lakh. My lord, this paragraph 15, I'm sorry. My lord, this paragraph 15 of Meena Devi also refers to one Kurwan Ansari.
Okay, this Meena Devi, that is, okay, para 15.
Para 15, my lord, Kishan Gopal, I have given to your lordship. Reference, Kishan Gopal has given 5 lakh. Your lordship will kindly write down the consolidated sum. And then, my lord, after Kishan Gopal, another reference in paragraph 16 is Kurwan Ansari. Supreme Court, my lord, this is Kurwan Ansari. This has given 4,70,000, 470. Your lordship will kindly just keep a note of the total sum.
This is 163A.
Lordship, yes, but my lord, the calculation is of 166.
4,60,000.
470, 4,70,000. My lord, Kurwan Ansari is of 2021. Kishan Gopal is of 2013.
Yes.
And now, my lord, this Meena Devi, what I have given to your lordship, my lord, this is of 2022.
Right.
This also gives 5 lakh. My lord, I'll read out down the paragraph. 16. Thus, applying the ratio of the said judgments, my lord, judgments with judgments, Kurwan Ansari and Kishan Gopal, what I have handed over to your lordship.
Yes.
Looking to the age of the child in the present case is 12 years, which is identical to our case. The principles laid down in Kishan Gopal are aptly applicable to the facts of the present case. As per the ocular statement of the mother of the deceased, it's clear that the deceased was a brilliant student. Again, a brilliant student and is studying in a private school. Therefore, accepting the notional earning of rupees 30,000.
Oh, anyway, just one thing.
Lordship.
What I find here is this. Here, in case of minor, that dependency, personal expenditures are usually not taken into consideration.
No, my lord, these are, but in certain cases, those are
para
not.
16, I find.
Yes,
That is
it
not
is
taken
not.
into consideration.
It is not taken here. That is why, my lord, I am telling you, to your lordship.
That is why advice has come to 5 lakh.
My lord, that
Otherwise, it would have been less.
I'm extremely grateful to your lordship. My lord, what is the crux of my submission before your lordship? My lord, I am going for the consolidated sum. Individually, if your lordship will see each of the judgments, my lord, there would be defects, they would differ from pronacity. Then I'll place objections there. Then your lordship will not be able to come to a conclusion. I'm trying to assist your lordship, my lord, to come to a conclusion of approximately rupees 5 lakhs or less. 5 lakhs is the best. Supreme Court, my lord, after a lot of permutation combination, is reaching the 5 lakhs figure this way, that way. So, my lord, in death cases, my lord, sometimes, my lord, it is deducting personal expenses. Sometimes it is not. Sometimes it is giving extra on consortium. Sometimes it is not. Sometimes, my lord, it is taking monthly income more. Sometimes it is not. Somehow, this way or the other, they are trying to reach the figure of 5 lakhs.
Yes.
So if my lord takes up every single case individually, your lordship will find faults. But if the collective view is taken, my lord, it is approximately 5 lakh. This is why, my lord, I was trying to assist your lordship there. My lord, therefore, accepting, my lord, may I read, my lord?
Yes,
Meena
no,
Devi.
para 16 you need not read.
I'm extremely grateful to your lordship. Now, my lord, following this paragraph 16 and this Meena Devi, my lord, our Honorable High Court had passed a judgment, my lord, this Manovara Devi. My lord, Honorable Justice Ananya Bandyopadhyay, my lord, it is unreported judgment. Again, your lordship will kindly come to the last page. This way, that way, my lord, 5 lakh was decided, final. Consolidated. My lord, is there, my lord? 1,50,000 was granted by the tribunal. Honorable High Court, her ladyship, my lord, made it 5 lakhs by following this: Kishan Gopal, Kurwan Ansari, Meena Devi. So these are, they may be against me, my lord. They may be over and above 1,54,500, but still, my lord, so that this matter can be disposed of and your lordship can come to a specific finding, my lord, I have given these 4 judgments, 3 of Supreme Court. These are the latest ones, my lord, and one of, my lord, our own Honorable High Court, very recent judgment, my lord, which all say, my lord, more or less it should be 5 lakhs.
Okay. There are other decisions anyway. There are
My lord,
just
my lord, then
Sinner's decision was something else. All in 166.
yes.
That all factors, his family background, his nature of qualification.
Now, in view of pronacity, everything goes.
Anyway, different factors were taken into consideration.
Different factors were, but
after pronacity.
Thereafter pronacity. So that is why, my lord, I said, in view of pronacity, everything goes. And taking note of pronacity, all these judgments have been delivered. These all are of, my lord, after 17.
And considering the latest amendment also.
Considering the latest amendment also, my lord, amendments of 1990 came into effect of 2022. My lord, that is why I submitted, my lord, even the
5 lakh
it is
limit.
5 lakhs. 5 lakhs is the limit, my lord. That is the best. That is the best what my lord.
That is the best guideline.
That is the best guideline. That is the maximum what my lord can. Otherwise, my lord, I would prefer 1,54,500, whatever has been granted. That is more, and that is absolute correct in view of the year of accident.
There are several judgments. If I go through different judgments, there are different observations.
Lordship,
and I can pick up someone and come that he's entitled
I'm obliged to
50 lakh also.
It can go to 50 lakh also, but my lord, no.
I can just pick up some judgments and give 50 lakhs also.
And my lord, your lordship can pick up so many judgments where your lordship will stick to 1,54,500 only.
That also is possible.
Considering the year of accident, considering the year of the award passed by the tribunal.
Anyway, so these are the 4 decisions, 3 decisions, including unreported decision.
Including, no, my lord, 4 decisions.
One is unreported.
One is unreported and 3 more, my lord.
Yes,
Kishan Gopal, Kumran Ansari,
reported.
and Meena Devi.
Yes.
So these are the latest ones, my lord. The best your lordship can grant, my lord, is 5 lakhs. I say, my lord, lordship will dispose it off. I will not trouble your lordship. Otherwise, if the argument is concerned, my lord, my learned friend has got a lot of oratory skill, my lord. I can also try to match him, but my lord, I will not waste my lord's time, my lord. Without evidence, without exhibits, without dealing with the judgments, what he has given me, lord, what he did not give me the reference, I conclude my argument.
Your learned friend usually, I think so far my knowledge goes, usually does not appear in MV cases.
Yes, my lord. In one case, he has given me a lot of trouble. My lord, he has appeared. My lord, he gave.
No, MV cases you usually do not appear.
He is an excellent advocate, but sometimes
but
while he is against me,
he is experienced with other writ matters and civil matters. So this field he usually does not appear.
In one matter, my lord, before the division bench of Honorable Justice Indira Banerjee, my lord, I got 29 lakhs something because a student was, my lord, injured and his leg was to some extent amputated. and the award was
See,
passed.
here you see, there are different decisions,
My lord,
different awards were granted.
my lord,
So the court has to search, you have to search, your learned friend has to search,
my lord,
and then I have to see how much can be granted or
my lord.
how what less I can grant.
Because
It's
my
better
learned
to
friend,
come to
my learned friend
No,
is because he does only motor accident claims, so
he
he
gives
has
some
a very
solution
good
also.
stock,
No,
and
some
he is a
solution
very
also.
he is a very good orator also, because he can mold the right thing
No,
to
he is
wrong thing.
specialized in this matter.
Yes, yes, yes.
Lord,
I
what
do
have,
admit, I do
Lord,
admit,
I have not molded it. I have said that lordship will increase.
my lord. My lord, one thing, my lord.
Anyway, you see, considering the age, minor, considering the decisions, considering the time when the accident took place, you see, it should not be more than 5 lakhs.
My
At
lord,
best.
they
At
could
best,
have, my
at
lord,
best.
the insurance company, there was no, my lord, prohibition that insurance company could have settled the matter earlier, because it is within their prerogative, because they didn't.
My lord, he will
Because
get
I requested him time
20,
and again
20 now he will get
to
23
settle
years
the
interest.
issue. But my lord,
And
so far,
sisters will get it.
this document is concerned, because it is not like the cases which my learned friend has referred. Because the income tax document which I have, my lord, produced in favor of my evidence, my lord, that if your lordship, no, jeet gaya nahi. If your lordship kindly see this judgment.
No, I am not going to, you see, the more I see, the more we'll forget.
No, my lord, so far the evidence of income tax return.
Because you have not exhibited the.
No, exhibited.
No, in the paper book you have not exhibited. You see,
No, I have
would have
given.
been easier.
No, when it was given,
paper book in nahi.
my lord, it is in the lower court record, that is within your.
Usually, this is not the procedure, you see.
My,
At the time of preparing paper book, except second appeal,
my lord,
all these depositions and exhibits, they are incorporated in the paper books, as you know. Except in second appeals, yes, it may not be. But otherwise, this is the procedure.
my lord, actually the department has, my lord, made the mistake. Because we have not done
It
so.
was informal paper book.
My lord,
Anyway, you want to add anything?
my lord, only thing, my lord, relying upon that judgment, my lord, that the income relating to income, the evidence, because it is very much in the evidence.
Yes, maximum is 46,650.
46,350. And that is my sum and substance before your lordship, and your lordship kindly decide the matter.
Okay, take down.
And my lord, one more submission, my lord, in series of cases, my lord, the interest was given 9%. Here, the tribunal has given 8%. So, if your lordship can consider that,
No, not in
and
this
enhance
case.
9%, my lord, 1% more.
No question of interest. Learned advocates for the parties are present. Hard learned advocates. The appellants before this court, but the claimants before claimants in a case under section 166 of the Motor Vehicles Act 1988, and is aggrieved by the judgment and award dated 20th to 20/8/2009, passed by learned Judge 6th Bench, City Civil Court at Calcutta, in MACC number 114 of 2004. Stop. The appellant's claimants being aggrieved, the claimants being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. During pendency of this appeal, the original claimants appellants died, and the present appellants were impleaded in their place and state. The case of the claimants before the learned trial court may be summed up thus. All I have. On 2/9/2003, at about 6:30 a.m., the driver of the offending private bus of route number 45 capital A drove the same through CIT road from north to south direction in a rash and negligent manner, and endangering human life and safety of others, and when it reached near the Kakurgachi crossing on CIT road in front of petrol pump eastern side, knocked down deceased Chirag Sabu when he was trying to get down from the first gate of the said bus. Stop. He was knocked down by the rear wheel of the bus. As a result, the deceased got severe injuries on his person and was admitted to Charing Cross Nursing Home P Limited. Stop. Here, he died after a few hours. Stop. The claimants in the instant case claimed for rupees 2.27 crores. Stop. Pursuant to the institution of this claim case, notice was issued upon the opposite parties. Opposite party number 2, the respondent number 1, National Insurance Company Limited, contested the case by filing written statement. The issues were framed, and upon considering the evidence and upon hearing the learned advocates, learned trial judge was pleased to dispose the claim application by observing and directing as follows. Hence, it is ordered. Page 103 of the paper book. The claimants, the original claimants, appellants, being aggrieved by the said judgment and award, has come up with the instant appeal. Stop. Heard learned advocate for the appellant claimants and learned advocate for respondent number 1, national respondent number 1 or 2?
We're not respondent number 1.
1. Respondent number. So why
We're not respondent number 2 then? We're not, because
Yes,
Vishnu Pada is respondent number 1.
Okay, respondent number 2.
Lordship.
Peruse the materials on record. Learned advocate for the appellant submits that the victim was a brilliant student and was reading in class 9 at the time of accident. His income as per the income tax return was rupees 46,650, but the learned trial judge, without considering the same, has awarded compensation of rupees 1,54,500, which is very meager. Learned advocate further submits that the learned trial judge did not consider the guidelines while awarding the compensation. Learned advocate further relies upon the following judicial decisions. Number 1, Mrs. Helen C. Rebello and others versus respondent. Reported in, it's an unreported judgment, Helen C. Rebello. What is the citation? Oh, okay.
I'll give it to
Reported
you,
in
my lord's
Indian
office.
Kanun.
But I'll give it to my lord's office. I'm just
Okay.
checking it.
Being so number 2, State of Haryana and another versus Jasbir Kaur and others, reported in 2003 SCCs within bracket CRI 1671. Third is State of Haryana and okay, this is the same thing. Third is Resham Devi and others versus Rajesh and others, being FAO 2881 of 2009 before the Honorable High Court of Punjab and Haryana at Chandigarh. Last holo B.V. Mekala versus M. Malathi and another, reported in 22 SCC 178 of 2014. Mr. Singh, learned counsel for the respondent number 2, National Insurance Company Limited submits that the learned trial judge took consideration of the notional income in the year 2004, when the notional income considered in motor accident claim cases was not more than rupees 15,000 per
Year 2003.
no,
Accident
the
was-
case is of 2004.
But not the accident was of 2003.
2003 either 3 করে দিন by the tribunals was rupees 15,000 per annum. Learned advocate further submits that the victim was aged about 13 years and the income relied by the claimants was from gifts and the interest on the investments. Stop. Learned advocate further submits that the award of compensation is just and reasonable. Stop. Learned advocate also relies upon the following judicial decisions. Number 1, Meena Devi versus Nunu Chand Mahato, reported in 2023, 1 SCC, page 204. Second, 2022, 1 SCC 317. Third is Ishan Gopal and another versus Lala and others, reported in 2014, 1 SCC 244. Learned advocate further submits that learned coordinate bench of this court, considering the decision of Meena Devi, has awarded compensation of rupees 5 lakh in the case of death of a minor. The case being FMA 444 of 2025. Upon considering the facts of the case and upon hearing the learned advocates, it appears from record that the income relied upon by the claimants was from gifts and different investments. Thus, the observation made by the learned trial judge that the income of the victim was 46,850 per annum was not from personal earnings. Hence, this finding cannot be disturbed. Although a minor who is a student may not contribute financially to the family, but considering his role played in the family and considering the age, the notional income should be considered, which is decided in different judicial decisions, and in the view of this court, it should be rupees 3,000 per month. In the instant case also, considering the fact that the victim was a student of class 9, the family background and the school which he was studying, the notional income of rupees 3,000 is just and reasonable. By considering the future prospect and the yearly income and the compensation on the ground on the heads of general damages, the compensation would exceed rupees 5 lakh. But considering the decisions of the Honorable Supreme Court in the cases relied upon, this court is of the view that it would be just and reasonable if the claimants are awarded compensation of rupees 5 lakh. Hence, this appeal FMA 444 of 2025 stands disposed. FMA 444 na. FMA 292 of 2010 stands disposed. The judgment and award passed by learned Judge, 6th Bench, City Civil Court, Calcutta, in MSCC number 114 of 2004, dated 28/2009, is modified to the extent that the claimants would be entitled to a compensation of rupees 5 lakh, along with interest at the rate of 6% per annum.
My lord, it was in the order 8%, my lord.
Very well, I think 6% is the reasonable.
My lord, kindly consider that aspect.
6%
Because
per
the
annum.
judgment I have referred 9%,
Very well.
12% is there.
But the court has to give some just and reasonable interest. 6% per annum from the date of filing of the claim case till today. The respondent number 2 insurance company shall deposit the awarded sum along with interest within 8 weeks.
Shall
from-
deposit the balance awarded sum.
Within
My lord,
8 weeks.
We have not received anything.
8 weeks
We have not
from
received
the
anything. 50,000 only.
of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already paid, the balance amount shall be deposited by the respondent number 2, National Insurance Company Limited. The appellant's claimants shall be entitled to withdraw the sum deposited along with accrued interest upon compliance of all necessary formalities.
My lord, the substituted claimants, my lord.
Anyway, appellants. I made it appellants.
My lord, that's true, but their record, they will.
Stroke this substituted claimants.
My lord,
Appellants after all.
Well,
Yes.
my lord, deposit is to be made within 8 weeks from the date of
Date of communication of this-
communication of this.
Yes, yes.
Extremely grateful, Your Lordship. Extremely grateful to my lord. Lord, sorry for my lord's taking some time. my lord.
Okay, thank you.
Grateful, your lordship.
You see, there are two differences. One who is seasoned in this MSCC cases, their way of handling, and the others who are not so seasoned.
My lord.
So,
No, my lord,
there's
because
different ways of handling.
of my health problem, my lord,
No, I'm not talking about health.
Yes.
Because you
No,
see,
no, no, your lordship is absolutely right.
experienced in other civil matters. Okay.
What Mr.
এটা দিয়ে দিন।
Singh has impressed your lordship, that's correct, my lord.
Okay.
I agree to
I'm
that.
thankful to my lordship.
Okay, thank you.
Grateful, your lordship.
Yes, call the original set.
My lord, one indulgence, my lord. Item 22, my lord, with great difficulty I could get it listed, my lord, with my lord's sleeve. 22, my lord, the execution is fixed tomorrow.
22.
22.
আচ্ছা এই একটু একটা অর্ডার রেকর্ড করে নিন তো I'll take it up. I'm just granting
Lordship.
some protection.
Lordship,
Learned
lordship.
advocates for the appellant is present. No time today. The case stands adjourned till
Wednesday, till 9th.
9/2/2026.
9/2.
As the matter is sub judice before this court,
Lordship.
parties may seek adjournment before the trial court stroke executing court, which may be considered.
Extremely grateful. My lord, let the order be uploaded today, my lord.
Yes, yes, yes. এটা একটু দিয়ে দেবেন আমাকে আজকে টিপিডিসি থেকে পাঠিয়ে দেবেন।
Extremely obliged for the indulgence, my lord. Grateful.
Yes, call the original side matters.
My lord, item 24 also, Mr. Singh is the
Thank you.
opposite side.
Item 20,
24.
it will be taken up on the next day. আচ্ছা ফিক্স ম্যাটারটা রেখে দিন আরেকটা আছে ফিক্স ম্যাটার আছে কি ঠিক আছে yes original side matters আচ্ছা ঠিক আছে আমি চেঞ্জ করে দেবো লেট ইট অ্যাপিয়ার বলে দিয়ে দেবো কবে আছে
ফেব্রুয়ারি
ঠিক আছে ওটা অর্ডারটা তাহলে রেকর্ড করতে হবে yes call the original side list yes
But I appear for the respondent. Probably none is there. Well, next week in that case.
Yes, let this matter appear on. A learned advocate for the respondent is present. Let this matter appear on 6/1/6/2/2026.
Fortnight, my lord. Decree is not yet drawn up. Unless it is drawn up, I can't put it in execution.
Okay, 14/2/2026. আচ্ছা 14 ওটা 13 13/2/2026 করে দিন।
Well, though it is little, well, when other side is,
I think it is better if you if it is on 6th. Otherwise, we don't know the matter. Maybe আচ্ছা ওটাকে 13 না 6 তারিখে করে দিন।
what is there, my lord, as your lordship, well, Mr. Thakkar come, he will address.
Yes, call the next.
My lord, I am appearing on behalf of the defendant number 36. The matter had last appeared before my lord on January
It was
22nd,
due to appear when?
20th February. It was due to appear today, but we mentioned the matter, my lord, because there was this typographical error.
Okay, let
30th
this matter appear on 20th February.
It's already recorded in the 22nd January order, my.
Yes, as this matter is due to appear, yes, learned advocate for the
Defendant number 36.
defendant number 36 is present. As this matter is due to appear on 20th February 2026, let it be listed on the said day.
Much obliged.
Well, may I mention one matter? Today is fixed on the item number 3. That was fixed on at 10:30. But item number 3, my commission is both side of
My lord,
Anyway, I shall fix another date, okay? On Monday, I shall fix another date. So Monday it will appear, another date will be fixed.
my lord, may I just make one? I was
This item
addressing,
number 2, I'm led by Mr. Dema.
I was addressing, my lord, the only thing, my lord, Mr. Mitro is also there, Siddhartha Mitro. Now, my lord, we are suffering an order because suit can't be transferred to the undefended list. On the last day when the matter was heard, because of the urgency, my lord, lordship was pleased to fix the matter today. Somehow, my lord, probably there was a mistake in recording the order, my lord, the person who recorded the order. 31st January was shown. So that is tomorrow, Saturday. Court is not functioning. When it appeared in the to be mentioned, lordship fixed it on 20th February. That
No, in the presence of the advocates. It appeared as to be mentioned. In the presence of the advocates, I
but
fixed the date.
today the matter is also appearing, my lord.
Anyway, by mistake.
Today is
Yes.
20th February will be too late, my lord.
See, that is
I know, I was not there on that day.
decided. Your junior was there.
Yes, he was there.
Yes, other advocates were there. Upon hearing them, I fixed that date.
Possibly they were not in a position to file the affidavit, my lord.
Very well, you see. But 20 definitely it will be taken up.
Kindly, my lord, finish
Priority
it
will
off.
be
Yes,
given.
because
এই 20 তারিখ ওটাকে একদম top of the list করে
absolutely, my lord. Otherwise, my lord, everyone will come and this will continue forever. Let this come to an end. Lordship has got this. One is coming with an application, another is coming with an application. I have to file.
It will be taken up on priority basis.
Absolutely, I'm grateful. Kindly makes it at the top, my lord.
Yes, yes, top.
Grateful.
It appear at the top.
Grateful.